What's up, everybody? There are more Kohberger documents. We're going to focus on one of them, but we are going to give a brief, just quick overview of what the other ones are and what they mean. We'll look at them real quick together. So many of you sent these to me this morning. This was obviously not planned. This is the definition of a last-minute live because I've got a couple appointments stacked on top of each other starting at 10 o'clock this morning. So I've got a hard out a couple minutes before 10 o'clock. And they're kind of stacked throughout the rest of the day. Tonight, we'll talk YNW Melly most likely. But this was the only opportunity I really had to read through this longer motion together, which I have not read yet, which is pretty normal for this channel. You guys send me something. Let's read it together. Let's see what it says. Let's try to figure out what they're arguing, try to figure out what it proves, try to figure out what the answer is going to be if they're asking the judge to do something. So this is the reason you need to subscribe to this channel and hit that reminder bell. We literally pull these last minute lives when something happens and the bat signal has gone up on Twitter and Instagram where people are sending me this stuff saying, what does this mean? Is this actual evidence? Is this something they're going to put before a jury? Because I have heard there's a lot to discuss about the DNA evidence that the state has described in the motion we are going to read together today. But first, hit that like button. Hit it. And let's look at just the documents that have been filed on June 16th is the new kind of chunk of documents. So the defendant's fourth supplemental request for discovery is exactly what it always is. Hey, give us more documents. Then there was a motion for protective order on some of the stuff the defendant turned over. The court ordered that to be sealed. The state stipulated to it. There were no real issues with that. And the state has also filed an additional response to the defendant's amended motion to stay that we read together on the last video. I think it was Friday or whatever, at some point last week, where the defendant just kind of added a little bit to their motion to stay. And the state basically said, we incorporate our last objection to the motion to stay, basically making all the same arguments. So we don't need to read through any of that. What we are going to read is the state's motion for a protective order. That is the main juice to get to today. So let me pull that up now. All right. So here we go. You can throw your questions in. We will star them. We will answer them. I'll probably take a break every, 5 pages. I think it's about 20 pages of actual argument and background. I'll take a break every 5 pages and answer questions. So get those in, but I'm going to focus on trying to get through this document as efficiently as possible while still breaking down everything that's important and discussing everything we learned that's new in this document. So here we go. If you join the party late, no big deal. Get in the comments. Let me know your questions there later, and we will take a look at them. All right, so it's just motion for protective order, which usually, if it's motion for protective order on DNA evidence that the state wants to protect, the other people that this could be connected to and other names that could come out that nobody knows about at this point because of all the media scrutiny, 100% this is going to get granted. But is that all they're asking for? That's the question. Comes now, State of Idaho, by and through their attorney, respectfully moves this court, pursuant to ICR 16.1, for information related to investigative genetic genealogy, aka IgG. So this is the way that they investigate the genealogy. This case arises from a quadruple homicide. Law enforcement found the DNA of a potential suspect, Brian Kohberger, at the crime scene, and the FBI submitted the DNA to one or more publicly available genetic genealogy services to determine potential relatives of the suspect. So one thing to keep in mind as we read through this motion, if I'm the defense attorney on the case, I am taking this motion and it is being worked into my outline of depositions for all law enforcement officers, all FBI agents, everybody that potentially worked on the investigation dealing with the DNA. The FBI then used common genealogical techniques to develop a family tree leading to the defendant. The state seeks to protect from disclosure the names and personal information of hundreds of innocent relatives on the family tree. The names of the publicly available genetic genealogy services used, and certain motion for protective order. And certain other information described below. So they're looking to protect and not make public the names of all the relatives, the names of the genetic genealogy services, and then other information. So I like how they say hundreds of innocent relatives, and you can infer from that, unlike the guilty defendant, is what the state's saying. They don't actually say that, but that's what they think, obviously. And they should, by the way. The state attorney and their office and law enforcement that are actively working on the case, they should think they have the right guy. They should think they have evidence beyond reasonable doubt. People on the outside that haven't seen anything, we should not be jumping to conclusions because we don't know everything. But it's okay for them to be very confident in their case and believe they have the right guy, or he shouldn't be sitting there. Just want to make that clear. They also want to make sure that the names of the actual services they used stay protected, which is interesting. Why don't they want the public to know? Was it 23andMe? What did they use? The disclosure of this information is not required by Rule 16 and should be protected from disclosure for the good cause described below, including the state's privilege to protect the identity of informers as described in Idaho Rule of Evidence 509. That's interesting. That's how they're going to connect it. Let's get a factual background. How did we get here? How is the DNA relevant? I hope they answer those questions for us. On November 13th, 2022, law enforcement found the bodies of Madison Mogen, Kaylee Gonsalves, Xana Kernodle, and Ethan Chapin at 1122 King Road in Moscow, Idaho. All 4 victims passed from apparent knife wounds. Law enforcement found a K-bar knife sheath on a bed next to Madison and Kaylee. So the sheath was on a bed next to 2 of the victims. The sheath was face down and partially under Madison and the comforter on the bed. To me, this seems like new details. I don't know. Maybe this was described in this detail before, but it's clear they found the sheath there. They found it next to the crime. They found it at the scene. And for the first time, we maybe realize how this happened. How did whoever did this, whether it's Brian Kohberger or the defendant, how did they leave the sheath behind? It made no sense. Did they do it on purpose? Were they framing Brian Kohberger? Did Brian Kohberger, if it wasn't him, if it was him, did he want to get caught? Is this part of an experiment? But we kind of get an idea. They can't use 23andMe by law, Ashley Oak said. I was just kidding. But did he drop it? Did it come off the knife? Whoever did this, and then it got underneath a body in the comforter, and therefore you couldn't see it on your way out? Kind of seems like at least some logical reasoning as to why somebody that turned off their phone and did all this other stuff they're saying Kohberger did, but then left the sheath there with his DNA on it. Okay, law enforcement seized the K-bar knife sheath pursuant to a search warrant. The Idaho State Police Lab in Meridian, Idaho, located DNA on the K-bar knife sheath. The ISP laboratory determined the DNA came from a single source and that source was male. That's our first step, right? That cuts half the population out. Once law enforcement had single source DNA from the K-bar knife sheath, they conducted what is called a short tandem repeat STR analysis. STR DNA analysis involves looking at 20 regions within human DNA and allows law enforcement to make a direct comparison between 2 STR DNA profiles. So we're getting a little insight into how this process works. What an expert is going to take the stand and explain. How did you get from the sheath to knowing that it was Brian Kohberger's DNA? Law enforcement submitted the STR DNA profile obtained by the K-bar or from the K-bar knife sheath to the Combined DNA Index System, CODIS, a database of STR DNA profiles from convicted offenders, arrestees, and crime scene evidence to identify the source of the DNA. No match was found, which means no Kohberger DNA was on file prior to this case. So everybody that's saying, oh, he must have done this before, I'm sure he broke into that lady's house, or I'm sure he committed this crime in Pennsylvania, there's no evidence of that. He's not in the system. He has no prior arrests, or what all the reports are. Obviously, that could change. We could find out more information throughout the process, like always. But what we know right now is there is no evidence of any prior crimes. And I think we need to remember that as we go through this process. And as they stack up evidence, like it seems to me like they're going to connect his DNA to the knife sheath, and you're going to hear me say that is almost impossible to get over if I'm a juror and I'm sitting there and they have the car stuff, they have the cell phone stuff, they have the pinging. Maybe he follows them on social media. But when they put his DNA on the weapon sheath at the scene of the crime next to the bodies, that's going to be tough to overcome. Unable to find a match using the STR DNA analysis, law enforcement decided to use investigative genetic genealogy to find a lead. Genetic genealogy allows individuals to trace their lineage or connect with unknown family members using DNA. Typically, it involves sending a DNA sample, such as a tube of saliva, to a genetic genealogy service like Ancestry.com or 23andMe. Ding, ding. The genetic genealogy service then creates a single nucleotide polymorphism, I'm sure I'm going to mispronounce some of these words, profile to use for genetic genealogical purposes. A SNP profile is different than an STR DNA profile and is used more often for genealogical purposes. So what's fun about, having this channel and having all of you listening and being in the chat, some of you are scientists and study genetics or nursing and medicine, whatever it is. And it's cool when people will tell me, hey, this is how it's pronounced or whatever. So I do my best, but some of this stuff, just as I'm reading 20 pages out loud and explaining, it gets a little tongue twisty sometimes. What's interesting, lots of budding forensic scientists are eating this up, Peter Secret Twist said. Yeah, exactly. So what's interesting about this is they are using services that people use, and you're getting a little view into how lawyers sometimes have to educate judges. Whether they used Ancestry.com or 23andMe, it still helps in explaining to the judge what we're talking about. Because if you explain it with just the verbiage, the judge may be like, what are they talking about? But as soon as they say, oh, it's like 23andMe or Ancestry.com, the judge's like, oh, yeah, to see who your family tree is. And as technology advances, we are seeing cell phone data in every criminal case. We're seeing steps in every criminal case, location, every criminal case, even cars, the GMC or Teslas or whatever it is. You can see where it is, how fast it's going. Download the black box data. It wasn't long ago when, for our accident cases or wrongful death cases and trucking or whatever it may be, when we would go to download the black box data, that some cars just didn't have it. It's very unusual now for them not to have it. So as technology advances, there's going to be more evidence that the state is going to have to educate the judge and the jury on that are incredibly important. And that's going to be part of a lawyer's job. All right. The genetic genealogy service then uses an algorithm to compare the user's SNP profile to SNP profiles submitted to the genetic genealogy service by, hold on a second. Sorry. John just sent me a text. Okay. The genetic genealogy service shares, SNP submitted to the genetic genealogy services by other users to determine ancestry and potential relatives. The genetic genealogy service shares with the user a list of potential relatives, and depending on the specific genetic genealogy service, personally identifying information on those individuals like their name, email address, the amount of DNA the user shares with potential relatives, the user does not receive any genetic information pertaining to other database users, i.e. users' DNA profiles that are not shared with each other. So they're saying, if we produce this stuff, you're going to get the names, email addresses, and other personal identifiable information of innocent people. And we have actually been involved in lawsuits federally about when companies like Ancestry.com, not Ancestry.com, but like that, have a hack and that PII, the personally identifiable information, gets leaked. And then people steal identities, open credit cards, file fake tax returns. And it can be a seriously annoying event in people's lives and cost them lots of money, cost them jobs, cost them their credit reports so they can't buy houses, cars, whatever it may be. So protecting people's PII or personally identifiable information is of the utmost importance. And companies have literally had to pay millions of dollars because there's phishing and whaling schemes. So I think the state has a very good argument to protect this information. The same process used frequently by members of the public can also be used by law enforcement as part of their investigation, a technique referred to as investigative genetic genealogy, or IgG. I'm ready for them to start calling it IgG. Once a publicly available genetic genealogy service shows law enforcement potential relatives of the suspect, law enforcement applies traditional investigative and genealogical methods to build a family tree in an effort to follow the tree to the suspect or a close relative of the suspect. Family trees can be used to narrow down potential suspect based on factors such as age, gender, opportunity, known physical characteristics of the suspect, etc. In this case, investigators used IgG to begin the process of developing a lead to an individual who left DNA on the K-bar sheet. The Idaho State Police utilized a private laboratory to develop an SMP profile for the DNA on the K-bar sheath. The private laboratory started using genetic genealogy to develop a family tree. But after law enforcement decided the FBI would take over, the private laboratory ceased its efforts and sent the SMP profile to the FBI. So the FBI took over. Not unusual for them. The FBI uploaded the SMP profile to one or more publicly available genetic genealogy services to identify possible family members of the suspect based on the shared genetic data. By the way, this is also important because what information they're going to give on those other services and companies may be moot. If the FBI did all the work, the FBI is going to be able to testify. The FBI is going to be able to talk about the chain of custody, and we're not going to have any issues like that or the necessity of bringing in those other companies. That's why it's important. SNP is pronounced SNP. Thank you, Callie. All right. The FBI could then view through the genetic genealogy service portal information regarding potential relatives of the suspect who left DNA on the K-bar sheath. Based on information the FBI could see in genetic genealogy services portal, the FBI went to work building family trees on the genetic relatives to the suspect the DNA left at the crime scene in an attempt to identify the contributor of unknown DNA. The FBI built the family tree using the same tools and methods used by members of the public who wished to learn more about their ancestors. For example, the FBI consulted social media, viewed vital records such as birth and death certificates, and viewed other information already contained in the user portal for the genetic genealogy service, including unverified information submitted by other users of the genetic genealogy service. So, not all of this is FBI ironclad. Other people can submit information. They used social media to learn about which you can tell this person's married to this person. This is their son. Some people say this is my dad on social media. They can use that. And obviously birth and death certificates. The FBI also consulted subscription-based databases available to law enforcement for information on individual people. And this is why I always say, and I had friends when 23andMe was just starting, they wanted to do it, and family members. And I said, I mean, most people don't plan on committing a crime, especially most, moral people. But it can and will be used against you if there's ever an accusation made or something that could potentially be connected to you or a family member of yours. It absolutely can be used by law enforcement. So just understand that going in. And I'm pretty sure that's in their little waiver that you sign. The product of the genealogy conducted by the FBI was a family tree that contained the name, birth date, and death date, if applicable, of hundreds of relatives, as well as their familial connections between each other and the suspect, Brian C. Kohberger. So we're 5 pages in and we first hear his name. The FBI then sent to local law enforcement a tip to investigate the defendant. The IgG process pointed law enforcement toward the defendant, but it did not provide law enforcement with a substantive evidence of guilt. The FBI did not, for example, conduct a direct comparison between SNP profile and the K-bar knife sheath and defendant's SNP profile, or SNP. I'll try to say SNP. That type of direct comparison required the more traditional STR DNA analysis, which was conducted by the Idaho State Police, not the FBI. So there's going to be a conjunction of law enforcement officers from Idaho State Police and FBI that are going to have to testify to connect these DNA dots. That's what we can expect at trial if we get there. Prior to the FBI's IgG efforts, the ISP laboratory developed the traditional STR DNA profile from the DNA found on the K-bar knife sheath. After identification of the defendant, law enforcement recovered trash from the defendant's home home of the defendant's parents, and SIP laboratory did STR DNA analysis of items from the trash for comparison to the unknown crime scene DNA. So what they had was not enough. They had to go get more DNA. They had to get DNA from the trash at the parents' house, which they were able to do. And then once they had that DNA, they compared it with the DNA from the knife sheath. And this is how the process works. And that is what we are finding out through this motion. These are things that, to me, is kind of new information that we as the public were connecting certain dots or expecting certain things. But to hear it from the horse's mouth, from the state attorney, it is connecting these dots so we're understanding how and why we got here. All right. Prior to the FBI's IgG efforts, the ISP laboratory developed the traditional STR DNA profile from the defendant found in the K-bar knife sheath. After identification of defendant, law enforcement, I already read that. The comparison indicated the DNA found in the trash belonged to the biological father of the individual who left the DNA on the K-bar knife sheath. We knew all this. Pursuant to a search warrant, law enforcement then collected DNA from defendant via a buccal swab. A traditional STR DNA comparison was done between the STR profile found in the K-bar knife sheath and defendant's DNA. The comparison showed a statistical match. So now we're hearing, and we're going to get into how Brian Kohberger was a match to the DNA at the scene. Specifically, the STR profile is at least 5.37 octillion times more likely to be seen if defendant is the source than if an unrelated individual randomly selected from the general population is the source. What this means is, if you take that DNA and you put it on a transparent piece of paper like an X-ray, and you lined it all up, the DNA from the crime scene. Then you took Kohberger's DNA and you matched those up. It looks like a match. If you put mine up, there's a 5.37 octillion times more of a chance that it lines up with Kohberger's than mine. What does that mean? We heard testimony like that in the Murdoch trial. It means it's very, 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 very unlikely that this is anybody else's DNA than Kohberger. Now, this is still something that Kohberger can fight because of the way they found the DNA, what kind of DNA it is, and we'll kind of save that till we hear those arguments. Also, even if they prove it was his DNA, was this connected to the murder weapon? Was this the weapon, the sheath to the weapon that was used? How can you prove that? There's still arguments to be made, but this is very key and huge evidence for the state. Huge. Huge. All right. The genealogy conducted by the FBI resulted in a lead that pointed law enforcement to defendant, but it did not result in the creation of many documents or records. Ooh, that's interesting because they keep asking. This is directly connected in answering the defendant's question. They keep asking for all these records, all these documents. Give us what you have on the DNA. And this is the state saying, all this stuff that we did, all this testing that we did, there's not a ton of records or documents for us to produce. Much of the information relied on by the FBI was only viewed through their user portal in the publicly available genetic genealogy services and other investigative databases. The FBI did not download or create copies of those records. Convenient. No records, Morty, right? Once the defendant was in custody, the FBI removed the S&P profile from the genetic genealogy services pursuant to the United States Department of Justice interim policy for forensic genetic genealogy DNA analysis and searching, DOJ policy. This means the FBI no longer has access to view much of the information it used to create the family tree and cannot view it again without resubmitting the S&P profile to the genetic genealogy services. To the state's knowledge, the only records that reflect the FBI efforts to create the defendant's family tree is the family tree itself. Notes jotted down by FBI agents as they constructed the family tree, and any records created to document the removal of the S&P profile from the genetic genealogy services pursuant to the DOJ policy. The state has not seen, nor does the state possess, these records or copies of these records. And then we're about to get into the argument. So I'm going to answer some of your questions first, but that's frustrating. We did all this work, and here's how we connected it, and here's how we found out it was Brian Kohberger's dad, and then connected to Brian Kohberger, but no records. Sorry, we don't have records. We're not going to be able to explain to you or show you how we got there. And that is very frustrating. I know people are going to say, oh, who cares? It's the cops. They did their job. We've seen problems with that before. That's the first point. Secondarily, how are we supposed to decide and determine and scrutinize if this was done appropriately if we don't know how it was done? And I mean, we're going to take depositions. We're going to ask, and I say we, with the defense cap on, we're going to take depos. We're going to ask these questions, ask how they got there, ask about their notes. But how many times have we seen a report or a document that contradicts what a law enforcement officer says, especially years down the road or even months down the road? We'd always rather have the contemporaneous reports that were made at the time. And this is important because not just one life, Brian Kohberger, on the line, but also the 4 victims and their families. All those lives are on the line to get this done right and get the right guy. And if you're so confident that this is him and this is his DNA, why not just print out as you go screenshots of how you built his family tree? Listen, so on one side, the state's going to argue, and I don't have a ton of time to get into this, but on one side, the state's going to argue, oh, we have all this technology and we can prove he was here and not here and turned off his phone and his car went here. And this is how we connected his DNA. But they're going to act like it was so difficult to just take a screen grab of your computer as you built the DNA profile and the family tree to see how we went from step 1 to step 10 to connect this to Brian Kohberger 5.37 octillion times more than anybody else. I like this. William said it in a math class. If you don't show your work, you don't get credit. There's a reason for that, William. Because there's a lot of different ways you could have got the right answer, right? You could have cheated. You could have taken the class before. You could have guessed. And none of those things are good. None of those things are accomplishing the goal of the teacher. The teacher wants to know you did it right and you know how to do it. So it does matter. I know people are not going to like that. All right, let me get to a couple questions here quickly. Chris, does single source male DNA mean that that's the only DNA, or they found a sample that wasn't mixed, but there may have been other DNA on the sheath? It doesn't say whether or not it was the only DNA there. I would be shocked, obviously, if it was underneath, if it was at the scene and we can expect other DNA was everywhere. I would be surprised if there wasn't at least some of the victim DNA on there. But at this point, I don't think we know that answer. The architect, will the DNA evidence ultimately be admissible considering there isn't enough for the defense to test it independently? Wouldn't that be prejudicial? Yes. And the defense can make those arguments, but I do think it's going to end up being admissible. But that is an argument as far as a fair trial, right? Everybody's arguing against the media. This needs to be a fair trial. Well, let's apply that across the board. Ainsley, thank you for explaining everything. You are the best. Happy Wednesday. Thank you, Ainsley. Going to need to get my voice a rest after this one. Mercy Cat, the chain of custody was corrupt from the time the first LEO in the room didn't see that sheath and subsequent LEO found it. Touch DNA proves nothing. I don't know if it proves nothing, but there will be arguments against it. Beach Butterfly, nice shirt, bro. Like it. Thank you. Available in our merch store. Check it out. All right. Let's continue with the document here. John, why don't you throw up the new members while I read the argument here? And welcome to all the new members joining. The state seeks a protective order for a narrow category of information, namely information related to the use of IgG in this case. Idaho Criminal Rule 16 governs discovery and the proceedings. Rule 16 is broad, but it is not a free-for-all. The rule contemplates the exchange of discrete categories of information between the state and the defense. As relevant here, the rule contemplates the state will provide 3 discrete categories of information: any material or information that would tend to negate the guilt of the accused, any documents or objects that are material to the preparation of the defense, intended for use by the prosecutor as evidence at trial, or were obtained from the defendant or belong to the defendant, and reports of scientific tests or experiments. If a defendant believes he should receive information that does not fall within one of the discrete Rule 16 categories, the rule allows the defendant to seek an order from the court for information where the defendant can show a substantial need for information in the preparation of his case. How does this not fall into all of those categories, right? Like, come on. Here, the defendant served on the state a request for discovery that calls for the IgG information, even though the IgG information falls outside the Rule 16, without first obtaining an order from this court. The state now seeks, and the court should enter, an order protecting the information related to the use of IgG in this case. So this protective order is not like a motion to seal. It's not so the public doesn't get it. They are filing a motion for a protective order here to not allow the defense to get this information. The state seeks it to protect the following information: the raw data related to the SNP profile and the underlying laboratory documentation related to the development of the profile, such as the chain of custody forms, laboratory standard operating procedure, analyst notes, etc. All information related to IgG efforts in creating a family tree and identifying the defendant's potential relatives, including the identities of the genetic genealogy services and the personally identifying information of defendant's relatives. So first, that's what they're trying to block. Here's just what I'll say. This would be the easiest thing in the world for me to say, you have to give it to them if I was the judge. So that, to me, should be an easy yes. Why should the defense not get this? Now, if you want to do it under seal or, under a protective order so the public can't see it or get it, perfectly fine with that. Don't publicize this information, but the defense should get it. You're saying there's not even that many reports. So give them what you have. That's what I would say. The state does not seek to protect and has or will disclose the following information. Has or will. A genotype kit report from the private lab utilized by the Idaho State Police, which documents that a DNA test was performed. Thank you. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered from the defendant's parents' trash. That's good. They're going to turn that over. Information related to the STR DNA analysis conducted using the DNA recovered from the K-bar knife sheath and the DNA recovered by the defendant on his buccal swab. This court should grant an order protecting the IgG information in this case because the IgG information does not fit into any of the discrete categories listed in Rule 16, and good cause exists to protect the information, including the need to protect the privacy of the defendant's relatives. So you're protecting the identity of the defendant's relatives from the defendant to potentially not allow the defendant to maybe point the finger at a relative that the state believes is innocent. What if the defendant doesn't believe it's innocent? What if it connects up very much so with some distant cousin that also went to University of Idaho? I'm not saying that exists, but if it does, seems like that would be important and potentially exculpatory. Obviously, I'm not saying the state's hiding it because they think that, but they've been wrong before. Rule 16 does not require the disclosure of the IgG information because the IgG information is not exculpatory. How do we know? Right? Maybe the defense thinks it is. Rule 16A of the Idaho Criminal Code does not require disclosure of IgG because it does not tend to negate the guilt or reduce the potential punishment of the defendant. The rule requires the state to disclose any material or information in the prosecuting attorney's possession or control that tends to negate the guilt of the accused as to the offense charge or would tend to reduce the punishment. As written, this rule largely mirrors Brady, and the state has to produce the criminal defendant all material exculpatory information. But Rule 16 and Brady are limited to exculpatory information. They do not require the prosecutor to make a complete and detailed accounting to the defense of all police investigatory work on a case. While the question of whether IgG information must be disclosed as exculpatory is one of first impression in Idaho, the courts outside of Idaho have correctly decided that IgG information need not be disclosed as exculpatory. So, first impression in Idaho means they haven't dealt with it in their state yet, but other states have dealt with it and other states agree with the state. I disagree with the state. And again, funny is the wrong word. Isn't it interesting that when it behooves the state, they say, oh yes, we need to keep the media out, or the defense definitely wants the media out. So I'm not getting that twisted, but they will make arguments that we need to make sure the defendant's rights to a fair trial are protected. But it's but we don't want to give him this information. And if I'm weighing and balancing the importance of this information and keeping it private so he doesn't see his own relatives' names versus if they did something wrong through this process and the defense hires experts to look through it and proves that they did something wrong, then to me, it should absolutely be discoverable. In Green, law enforcement used DNA recovered from the victim's nightgown to identify the defendant as a potential suspect. Then they surreptitiously recovered items from the defendant's garbage that contained DNA and found through STR DNA testing that the DNA in the defendant's garbage matched DNA found on the victim's nightgown. A saliva test then confirmed the defendant's DNA matched the DNA on the victim's nightgown. Defendant moved to compel the disclosure of the IgG information. After an in-camera hearing, the court denied the motion. So maybe at the very least, they'll have an in-camera hearing here. The evidence that is material to the defendant's guilt or innocence is the testing that followed the IgG investigation, which directly compared a fresh swab of the defendant's DNA with the DNA profile collected from the victim's nightgown. It is only this evidence that the people intend to present at trial. The people are not obligated to provide its preliminary search of the genealogy databases for possible matches, which is investigatory in nature and is not exculpatory or material to the defendant's defense. So I will just tell you, I have been wrong before. Shocker, I know. And I have also felt like I am very, very right about things that judges decide in opposition to me. This would be one of those. I'm either dead wrong or I'm just going to disagree with this judge if they make this determination. Because now we're saying full investigation. Let's just pick out parts of potentially the most important piece of evidence. Why not give this to them? Don't let them use it inappropriately. If the defense tries to twist something or lie or commit fraud in how they use the IgG evidence, then stop it right there in its tracks and the judge don't allow it at trial. But why not let their experts look at this to see if something was done wrong, to see if the way that they eliminated other people was wrong, to see if some of the other people that were in the family tree or before they matched up this DNA is also somebody Brian Kohberger thinks did this and set him up for it. There are a lot of ways that I think I could argue that this could be potentially exculpatory. As this case illustrates, the state is not required to disclose the IgG information under Rule 16 because IgG information the state seeks to protect is not favorable to the defendant on the issues of guilt or punishment. The information provided to local law enforcement by the FBI was nothing more than a tip, a lead for local law enforcement to follow up on, should they choose to. They also want the tips, right? Again, for the same reason, they want the tips. The genealogical tip did not prove or substantiate the defendant's guilt. Rather, the tip allowed local law enforcement to focus their investigation on the defendant. I mean, if it helped them focus in on the defendant, that seems like it was pretty important to their investigation. And obtain independent material evidence of his guilt, all of which the state has disclosed and will disclose. Specifically, with respect to the DNA, an STR DNA analysis found defendant's DNA matched DNA collected on the sheath. To the extent the IgG information has any relevance, the fact that it led law enforcement to the defendant means it's inculpatory rather than exculpatory in nature. Thus, Rule 16 does not require it. So maybe they're saying there's a different rule they can use to say because it's relevant, they should get it. Maybe the defense should do that, because to me, it seems absolutely relevant, because if you want to pick it apart or show why it was wrong or done incorrectly, even being inculpatory or part of the investigation that pointed to the defendant, that is still important. So they're taking this rule, breaking it down piece by piece. Rule 16b(4) does not require the disclosure of the IgG information because the IgG information does not satisfy any of the required criteria. The nature of the IgG is such that its disclosure is not required. The rule requires disclosure of books, papers, documents, photographs, tangible objects, and buildings or places only when they are material to the preparation of the defense and are intended for use by the prosecutor as evidence at trial or were obtained from the defendant or belong to the defendant. So they're going to argue clearly that it's not material to preparation of the defense. That's where I think the defense would have the biggest argument, because number two, they can control this, that they're not going to use it as evidence at trial. And if they make this argument now and then use it as evidence later, the defense can bring this up. But as of now, they're saying they're not going to use it. And obviously, they're going to say the IgG information was not obtained from the defendant or belongs to the defendant. So we're going to kind of just skip through this one. Here, let's just read this part, the material to the defense. The immateriality of the IgG information to the preparation of the defense is perhaps best understood by way of analogy. The tip that came from the IgG process is no different than any other type of technology hits that put law enforcement on the trail of a suspect. For example, in Johnson, law enforcement recovered a suspect's DNA from a ball cap left outside the scene of the crime of a bank robbery. Law enforcement ran the DNA profile through CODIS, which resulted in multiple hits, including the defendant. A scientist narrowed down the hits to the defendant, and law enforcement confirmed it was the defendant's DNA after acquiring a swab from the defendant. The defendant moved to compel the CODIS hits from the government, but the court denied his motion. The court explained the DNA evidence material to the defense was the direct comparison between the DNA on the hat and the DNA taken directly from the defendant. The fact that the defendant was the first identified as a possible suspect based on the database search simply does not matter. Here, the IgG information, like the initial CODIS hits in Johnson, is not material. Moreover, the IgG information, and I disagree with that you can't make arguments off of that. I just objectively disagree. Moreover, and I go back to to other cases where we've seen evidence that seemed so sure, whether it's blood spatter or expert testimony, that then just goes away. Moreover, the IgG information could not support an argument that the defendant, that law enforcement violated his Fourth Amendment rights by engineering a DNA collected from the Kohberger sheath into a genetic genealogy service. I agree with that. So we can kind of skip through this. Basically, the fact that they used IgG is not violating his Fourth Amendment rights. But I do think that it could be material to the defense. They did not rely on the IgG information to establish probable cause for the defendant's arrest. They did not present the IgG information to the grand jury. That's new information. And they have no plans on presenting it. And has no plans to present the IgG information for which a protective order is sought as evidence at trial. No surprise there. Third, the documents are tangible objects. The defendant has no property and interest here. To the extent the Kohberger sheath once belonged to the defendant, he abandoned it and his DNA. I don't think he's going to make that argument. That was my sheath. You got to give it back to me. All right. Next section here. Again, I've only got about 10 minutes left, so I'm going to try to buzz through this. Rule 16b-5 does not require the disclosure of the IgG information because the IgG information is not the result of a scientific test or experiment. It's not the result of it, right? It gave them the hits and then they did the results later is what they're going to argue. Rule 16 also requires the disclosure of information related to scientific experiments, but it only applies to limited information. Namely, Rule 16 requires the disclosure of results or reports of scientific tests, experiments made in connection with a particular case. The rule does not require the state to disclose what law enforcement does with the results or reports. Moreover, a process, procedure, or investigative technique is not a scientific test or experiment, merely because it involves the comparison of information or objects or requires the use of logic or reason. I don't disagree with the state here. There are two types of scientific tests conducted with respect to the DNA that fall within the purview of Rule 16.5. First, the STR DNA, which they're going to give up. Rule 16.5 does not require the state to disclose how the SNP profile was used. So they already made that argument. Starting with the potential relatives, the FBI engaged in traditional genealogy to put together a family tree that could lead them to the suspect. Putting together the family tree required the FBI to use resources such as social media, publicly available databases, subscription-based databases, vital records like birth certificates, census records, and historical newspapers. None of these actions are accurately characterized as a scientific test or experiment. I don't necessarily disagree with them. I still think they're discoverable, though, under the other rules. All right. Good cause exists for the court to enter an order protecting the IgG information, and if necessary, the court should hold an in-camera hearing. I think at the very least, the court is going to hold an in-camera hearing. The mere fact that the IgG information does not fall within Rule 16 is reason enough for this court to enter an order protecting the IgG information and therefore allowing the state to not turn it over to the defense. But the state is not seeking the protection of IgG information as an exercise in obstinance. We're not just trying to block it. We're not just trying to be difficult here, Judge. Instead, the state seeks to protect hundreds of innocent civilians from having their personal information, including their names, birth dates, and familial connections to the defendant in a high-profile quadruple homicide from being disclosed. The disclosure of the IgG information risks harm not only to these indirect informants, they're informants only because they were connected through social media and other databases. Indirect informants, but also the genetic genealogy services used by the FBI and the IgG investigative technique, meaning we want to keep that private. We don't want to tell criminals how we do this, or else they'll be able to try to get around it. This court should follow the procedure laid out by Idaho's appellate courts to determine whether the IGG information must be disclosed. 1. Providing the IGG information would require the disclosure of identity of informants and prejudice the state. The process used to collect the IGG information required gathering information from several informants, including the genetic genealogy services to which the SNP profile was submitted, and indirectly from the relatives of the defendant who hit on the SNP profile. Pursuant to Rule 16, disclosure must not be required of an informant's identity unless the informant is to be produced as a witness at a hearing or trial. The state has no intent of presenting the IGG information. We already know that. None of the informants will be produced as witnesses. This non-disclosure of this information is consistent with the state privilege to refuse to disclose the identity of a person who has furnished information relating to or assisting in the investigation of a possible violation of law to a law enforcement officer. The reason this is a thing is because we want to be able to catch criminals. We want to protect informants. And if informants give information to the state, we want the state to be able to use that. And if they're not going to rely on the informant's information, and this is important because of how I've kind of been talking about all of this, it is important that if the state wants to use something an informant gives them and then go and investigate and find the actual evidence, they have to turn over the evidence and produce the evidence. They don't necessarily have to produce the informant. It's like saying, the informant saying, go look at the video at that 7-Eleven because all of this happened and I bet that video captured it. And if the state goes and looks at that video and it has the video of the crime on it, they have to turn over the video. They have to turn over how 7-Eleven keeps that video, but they don't have to turn over the informant because the way they were pointed to that video is not necessarily evidence. And that's what they're trying to connect this IGG stuff with. Now, the reason I disagree with that is because this IGG stuff is more like an informant saying, it could have been any of these places. It could have been any of these spots. And we want to know all the different spots it could have been. That's where I think there's a difference. But I can see the arguments made on both sides. As a general matter, we protect the identity of informants. We encourage the flow of information concerning commission of crimes. Okay, I guess I didn't need to stop and explain this because they're going to explain it here. Such commissions are discouraged if the informant's identity is disclosed. The court's words, written long before SNP profiles were used for investigative purposes, apply with particular force to IGG information. Both the genetic genealogy services to which law enforcement agencies submit a suspect's SNP profile and the customers of those genetic genealogy services who may unknowingly be related to a suspect would be less likely to make their information available if the courts start requiring the disclosure of their information in criminal cases, especially in high-profile criminal cases. Yeah, well, guess what? We as the general public don't want the court to force us producing our DNA. The court retains wide discretion to protect against the disclosure of information that might unduly hamper the prosecution or violate some other legitimate government interest. 5 minutes left and 3 pages. I don't think we're going to get through it. This court should follow the process laid out by Idaho's appellate courts to determine whether the IGG information must be disclosed. Rule 16 allows this court to enter a protective order for good cause. If the court finds it's necessary to review the evidence in camera to decide whether disclosure is required, the rule itself allows the court to do so. The rule expressly contemplates that in deciding whether to enter a protective order, the court may permit a party to show good cause by written statement that the court will inspect ex parte. If the relief is granted, the court must preserve and seal the entire text of the party statement. Okay, so we have that here. They're going to at least ask for an in-camera review. Yeah, so I think at the very least, they're going to do an in-camera review before they make this decision. And even if the court finds that the IGG information falls within Rule 16, the court should follow the guideposts that Idaho appellate courts have planted in the protection of the informants. The defendant should first be required to establish that the IGG information is in fact relevant to the charges against him. If he can do so, this court should allow the state to present information at an in-camera hearing for the court to determine whether the IGG information must be disclosed. So what they're saying here is, first, force the defendant to tell you why they need this IGG information, how it fits into Rule 16, not just that it could. Fair. But once the defendant does that, the state then wants to respond and say, here's why it doesn't. And then the court needs to look at the IGG information in camera and decide, does it fit the defense's argument or does it fit the state's argument? And then the judge will do what a judge does and make a decision. The judge is going to judge. All right. Judge is going to judge. Conclusion. Based on the above, the state respectfully prays the court to enter an order protecting the IGG information from disclosure as it falls outside the purview of Rule 16 In the alternative, if the defense can establish the IGG information is in fact relevant, the state asks this court to conduct the requisite in-camera hearing. Okay, and that's it. So here's what's important to note. The defense wants this information. The state doesn't want to give it. So now we're at a crossroads. So I think the right decision from the judge is to do what the state just said there at the end. Defense, tell me why you need it. And if the defense can in any way show that this might be potentially relevant or something that they might use or that they think connects to evidence the state is going to use in a way that they should at least get it and get to ask law enforcement questions on it, then I think the judge should then listen to the state's argument, look at the stuff in camera, and if the judge thinks at all that the defense might be able to use this, they should absolutely deny this motion for protective order and compel the state to turn over not just the 3 things that they agreed to turn over, but the other 2 that they wanted to block. My opinion. Okay. But I want to know what you think in the comments. Please let me know. Truth and transparency. Exactly. Math class. We didn't get credit for no work. Nah, a man's life is on the line. It's all good. No work needed. Equals straight BS. Thanks, lawyer. You know. Now, some of it may not be relevant, but if it is even has the potential to lead to relevant information, I think it should be disclosed. Azam, Peter, if there's no record, could it be fruit of the poisonous tree? No. Well, yes, it could, because they could have done something wrong. They could have violated his rights. They could have committed a crime to make it fruit of the poisonous tree, but that's not what no records means. Fruit of the poisonous tree means you got information illegally or wrongfully, and therefore you can't use anything that led to that. So if they got the information illegally that led to the DNA evidence, then sure, it could be. Stephanie, so the DOJ policy about DNA genealogy evidence is to erase the existence. Am I understanding that right? To delete it once you get everything you need, which is very weird. But again, all of that, I think at the very least, you should be able to make that argument in front of the jury if you're the defense. And if you don't like it and you think it's a prejudicial argument, then maybe don't do that and don't make that your policy. Sonia, Peter, is it possible that they are hiding something that is helpful to the defense, or is this normal? This is pretty normal. I don't think they're necessarily trying to hide something from the defense. I think what they don't want is the defense to get all this information and potentially find a way to try to pin it on a relative or pin it on somebody else that may have somewhat connected to this DNA. They don't want the defense to make a mountain out of a molehill. So they're trying to eliminate as many molehills as they can. That's my guess. K-Rab. Taking screenshots is impractical since you may view hundreds, if not thousands of records to determine if the person in the record belongs in the tree. Ultimately, the proof is a standard test of the evidence DNA and the suspect DNA. K-Rab, I understand that. I think that's fair. I think the state can make that argument. How many terabytes of data did they turn over? A couple thousand more documents. If I'm the defense and my life is on the line, if I'm the defendant, I think it's worth it. And from the FBI's point of view, you can literally just screen grab with a, control whatever screen grab as you go. They all save into a screen grab folder and then you save it there. So I don't think it's an unreasonable amount of time, but reasonable minds may disagree. Stephanie, I think the tip analogy makes sense. As long as they share the DNA profile that came from the sheath, are they saying they can do that? They can't do that. Thanks for decoding this for us, Peter. No, I think the state is saying they are going to share the DNA profile from the sheath. They are going to share the DNA profile from the trash and the connection that it is the defendant's. So that's what I'm saying. I think there are arguments on both sides of this. I really do. I just err on the side of let the defendant have the information. If you use the information, let him have it. John O'Rourke, you can also limit the way they can use it. That's what I'm saying. Just because they look at the information does not mean it's going to come in as evidence at trial. That's, I think, something we've got to remember if we haven't gone through a lot of these cases. John O'Rourke, did many people get flagged from the IGG info? I have no idea, John. I think that's a good question. Because the state's going to be able to say the 5.37 octillion whatever times different, but is that the same with all of these people that they got these tips from? Kathy, welcome to the membership crew. And it's 10 o'clock, so I've got to run. Azam, we're going to go out for this. Thanks for the bedtime story, Peter. Haha. Sleep well, Azam. And thank you, everybody, joining me on this last-minute live this morning. Please hit that like button because a lot of people have been asking me about this since, just last night. So I want them to know this video is out there. It's not during our regular live time, so your likes help get it out there. We've got almost 5,000 people in here. Let's get to 5,000 likes now. Subscribe to our page if you haven't already. I appreciate everybody showing up. And Sleuthy, thank you for making it easy for us. Control print screen. I think they should have done that. Just one man's opinion. You guys are the best as always. I love you. I cherish our time together and your questions and your comments. I really do. I learn a lot from how you look at things, and I appreciate all of you joining for this. Let's hit it to the outro. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.